relating to the inalienable right to life of every human being at every stage of development. Mr. Speaker, your Human Services Committee recommends do pass on Senate Concurrent Resolution 4009 by vote of 9 yeas, 4 nays, 0 absent, and 0 not voting. Mr. Speaker.
Representative Loyson.
Thank you, Mr. Speaker. Mr. Speaker and members of the Assembly, your Committee on Human Services recommends a do pass of Senate Concurrent Resolution 4009 with 9 yeas and 4 nays. This resolution, if passed and approved by the voters in the 2014 general election, would add a section to Article 1 of the North Dakota Constitution. The wording in the proposed section is quite simple. The inalienable right to life of every human being at any stage of development must be recognized and protected. A green vote would let the people of this great state decide if they want to protect life at every stage of development. Mr. Speaker, may I continue?
You may continue.
Thank you, Mr. Speaker, and members of the Assembly. The opponents of this bill argue this resolution will affect the end-of-life process or organ donation. This is false. Our Constitution in Article 1, Section 1 already states all individuals are by nature equally free and independent and have certain inalienable rights, among which are those of enjoying and defending life and liberty. Article 1, Section 2 states, government is instituted for the protection, security, and benefit of the people. If their accusations of this bill affecting the end-of-life process or organ donation were true, there would already be conflict because we already defend and protect the end of life in our Constitution. This bill also gives guidance to our state Supreme Court, saying the Constitution does not grant a right to an unfettered abortion. Currently, there is a case tied up in court in which the plaintiff is claiming that the North Dakota Constitution grants a right to an abortion that is greater than the scope of the right found in the U.S. Constitution. Mr. Speaker and members of the Assembly, let's stand up for those who can't speak, the unborn children. Let's grant them basic human rights. I urge your support of Senate Concurrent Resolution 4009 so the voters of North Dakota have the chance to vote on this important issue. Thank you.
Is there any discussion? Representative Hake.
Thank you, Mr. Speaker. Will the bill carry or yield to a question?
Representative Loyson, will you yield to a question?
Yes, Mr. Speaker, I will.
Representative Hake.
Thank you, Mr. Speaker. According to this resolution, when does life begin?
Representative Loyson.
This resolution does not in any way say exactly when life begins. It says that we protect it when it does begin. That would have to come through our through legislation in future sessions if we wanted to define exactly when life begins.
Thank you.
Representative Mooney.
Thank you, Mr. Speaker and members of the Assembly. The words, the inalienable right to life of every human being at any state of development must be recognized and protected. Representative Loyson just referred to the Constitution as it exists today. I actually have great concerns that the language that would be suggested to change and alter our Constitution would actually challenge a great number of what we believe to be legally true today. The human being develops throughout the entirety of its life cycle. There is birth, certainly, but additionally there are stages that may include major illnesses, disease, and conditions outside of the human control, and then there's death. A constitutional amendment to codify the defense of life brings many concerns to mind, not the least of which includes the how that this will affect future legislation and legal standings on all of life's health issues. If we are to defend the right to life at all stages, how will this impact instances that include transplant? In these particular cases, the body is kept alive until the point of harvest, if at all possible, which most assuredly leads to the death for the person giving the organs. That's a fact. How will this affect terminal illnesses in instances where an individual requests no treatment? Is this defensible under the new constitutional amendment? How does this affect cases of DNR, do not resuscitate? Will healthcare providers, families, and individuals now find themselves in the throes of legal questions at a time when they are most deeply into a personal, very personal matter? How will this affect the many, many lives, or I'm sorry, many, many living wills now in existence in the state of North Dakota? Will these continue to be valid? Will they be challenged? How many people's lives will be affected by this very personal choice of their end-of-life wishes? I ask you, Mr. Speaker, and members of the Assembly to carefully consider these and no doubt the many, many other examples not listed here that will be affected in the aftermath of an amendment such as this. Ask yourselves the sheer number of laws that will be affected and potentially challenged. The vast number of bills to be drafted in the next legislative session alone, I dare say, would be vast and unsurmountable. With that, I ask for a no vote on Senate Concurrent Resolution 4009. Let's not open Pandora's box. Thank you, Mr. Speaker.
Is there further discussion? Representative Glassheim.
Thank you, Mr. Speaker. Members of the Assembly, if all religions agreed that a fetus was a person at every stage of development, then clearly abortion, even at 20 weeks, would be murder. But the question of when life begins and when a fetus is fully human are matters of religious doctrine. There is today, as there has been for several thousand years, significant disagreement between one religion and another. Let me summarize the official positions of 8 church denominations relative to abortion, and therefore on the absolute personhood of a fetus. The Episcopal Church condones abortions in case of rape or incest, cases in which a mother's physical or mental health is at risk, or cases involving fetal abnormality. The Evangelical Lutheran Church in America believes that abortion prior to viability of a fetus should not be prohibited by law. Viability is understood as when a fetus is able to survive outside the womb. After viability, abortion should be prohibited except when the life of the mother is threatened or when fetal abnormalities pose a fatal threat to the newborn. The Church of Jesus Christ of Latter-day Saints condones abortion only under circumstances such as a pregnancy that threatens the life of the mother or that has come about as a result of rape or incest. The Presbyterian Church affirms that the termination of a pregnancy is a personal decision. Though the Church disapproves of abortion as a means of birth control, it supports people who, on the basis of studying Scripture and prayerful decision, come to diverse conclusions and actions. The American Baptist Church USA acknowledges a division of opinion in their membership, and therefore their board opposes abortion as a means of birth control, but it counsels people considering having an abortion to prayerfully and conscientiously consider their decision. The United Methodist Church recognizes the tragic conflicts of life that may justify abortion, and in such cases they support the legal option under proper medical procedures by certified medical providers. Judaism, in principle, does not regard the fetus as a full human being. In Jewish law, the embryo is not considered an independent human person, but rather a subordinate part of a woman's body until the head is crowned. Also, Judaism recognizes psychiatric as well as physical factors in evaluating the potential threat the fetus poses to the mother. Reform Judaism believes that the decision about abortion should be left up to the woman within whose body the fetus is growing. The Unitarian Universalists affirm the right to choose contraception and abortion as legitimate aspects of the right to privacy. They view legislation against abortion as an infringement of the principle of separation of church and state, in that it tries to enact private morality into public law. Now, no church would condone abortion if church doctrine concluded that a fetus was a person at every stage of development. But after lengthy debate among their theologians, their clergies, their lay members, 8 mainstream denominations have adopted official church positions on when life begins, which are very different from the doctrine contained in 4009. If passed, at least these 8 religious denominations and their members would find themselves unable to act on their religious beliefs in North Dakota. If religious liberty and limited government mean anything in America, they mean that some religious denominations should refrain from using the power of secular government to impose their beliefs on denominations which do not share their faith. I ask that you rise above the temptation to legislate one religious belief for people who do not share that belief. I urge you to stay true to America's 500-year tradition that religious matters are to be decided by individual conscience rather than by the imposition of government power. Thank you, Mr. Speaker.
Is there further discussion? Representative N. Johnson.
Thank you, Mr. Speaker and members of the Assembly. I rise to oppose this constitutional amendment because of the potential impact on the end-of-life care. This addition to the Constitution states that we must protect every human being at any stage of development. That could apply to people who are at the end of their life as well as the beginning of life. A living will, also known as an advance directive, is a set of written instructions that specifies what action should be taken for a person's health if they are no longer able to make decisions due to illness or incapacity. Do you want life support or not? If so, what kind? My mother-in-law had an advance directive, but at the end of her life, we still had to make the decision to remove some of the life support systems because she was not able to. Would the excellent medical staff and her family have been in violation by making this difficult decision in opposition to her advance directive? And the language of this constitutional amendment could be interpreted to mean that living wills and advance directives cannot be followed if they instruct family members to discontinue life support because that would not be protecting the life of that person. This legislation will create an environment of confusion for healthcare providers and fear of prosecution. This bill is too extreme. Please vote no on Senate Bill Concurrent Resolution 4009.
Is there any further discussion? Representative Ruby.
Thank you, Mr. Speaker. Members of the Assembly, I find it interesting that there was a list of different religions that were listed, and one very substantially, one religion with substantial membership in the state was not mentioned. However, I don't see any language in here that references one religion's interpretation or definition in this language. This can be completely relied upon by science. The other thing, our Constitution already guarantees that people who are post-born, people who are already born, can decide their advance directives, their do not resuscitate, all the other provisions that we have in the law and the Constitution that guarantee the right to continue with wills, with final care, and all the things that we've heard would not. I think Representative Loyson did a great job in explaining that. I just wanted to remind the body. Thank you.
Is there any further discussion? Representative Overson.
Thank you, Mr. Speaker. Mr. Speaker, members of the Assembly, I stand in the strongest opposition to this resolution. You've heard the many arguments for and against the bill already. In testimony, many tried to reduce this bill to simply an issue of women's rights and her right to privacy in health care. The only thing that makes this a woman's issue, the only thing that makes this of more importance to me and my rights than to any man in this chamber is simply, and this might shock some of you, is the fact that I can get pregnant and you as a man cannot. As a young woman who has not yet had the great privilege of becoming a mother, I want to know that when I make a decision to do so, any already difficult decisions that I must face with my physician and my family will not be complicated by legal matters in the overreach of state government. This affects my future and the future of young mothers across the state more than it affects over 85% of this chamber. But again, as has been stated by many to speak before me, this is about so much more than women's rights. This is about legalizing one religion's viewpoint This threatens end-of-life decisions. This could complicate procurement of organs for people who are awaiting organ transplants, and so much more. When we asked for clarification on these potential complications in committee, we were told this could be worked out in further legislation. It is a terribly dangerous practice to pass laws that create many legal complications in so many arenas, to have no clarity on what exactly we're doing, and have no set plan to address these complications. The bill carrier solidified this when he stated that we do not know when this bill defines the beginning of life. What happens until we work these problems out? If we are going to say that all stages of development must be both recognized and protected, and that constitutionally our state would now be obligated to recognize and protect that life, there are, I believe, a number of bills that we would need to reconsider. For example, the bill that updated requirements for children's safety restraints in vehicles has already failed in this chamber. The argument was that this is not an area for the state to constantly step into. This is a parental decision on what measures they want to take in the name of their own children's safety. If we pass this resolution, this is no longer the case. The state now has a constitutional responsibility to protect those lives. It is out of the parents' hands, and we must pass all laws accordingly. I could go on with a number of bills that we would be obligated to pass due to this piece of legislation, but I think you understand my point. Mr. Speaker and members of the Assembly, this affects so many people in so many ways, and we have so many questions on what exactly we're doing. How can we, with a clear conscience, pass such a dangerous piece of legislation in answer to our constituents when they have questions about what we just passed? We are not doing our job if we move forward with this resolution. As a young professional woman who wants to stay in the state and start my family, and more importantly, as a representative of many others who share that same hope, I urge you to vote no on Senate Concurrent Resolution 4009. Thank you.
Representative Damschen.
Thank you, Mr. Speaker. Mr. Speaker and members of the Assembly, I really hesitate to add to the discussion because I realize there will be a lot of discussion and very few minds changed. But I do think we have to admit that we already protect life. We protect it at almost every stage, except the stage from conception to birth. And some people choose to protect it at that stage as well. And there can be argument. We can argue when life begins, but we cannot argue that not one of us in this assembly would be here if we had not survived every stage from now back to conception. There's no one here who has not survived every one of those stages to their current age. So I don't think we're out of line to say that someone or that no one should have a right to choose when an innocent life should be taken. And that's what I'm all for women's rights. I don't argue that they should have just as many rights as a man or anyone else. But I don't think a man or a woman should have that right to decide that it's okay to take the life of an innocent child. So thank you, Mr. Speaker.
Is there further discussion? Representative Casper.
Well, thank you, Mr. Speaker, members of the Assembly. You heard some discussion about what man says and what man's religions have created. But what about God? What does God say? For those of you who believe in God, He says, "Thou shalt not kill." He says in Scripture, "I knew you in your mother's womb. The hairs of your head are numbered." Scientifically, we know that to have a person, we have a union of a sperm and an egg. And scientists tell us that each sperm is unique and each egg is unique. So think back and make this a little bit personal about each one of us in this chamber. When our mother and father decided to have children, a wonderful thing was occurring. And one of the things was millions of spermatozoa, all unique, we're racing toward one egg in our mother's body. And only one spermatozoa, unless there's twins or triplets, won the race. So each one of us had one unique moment in time to be here today. And that was the moment of fertilization. Once the fertilization began is when we became the beginning of what we are today. So what is this resolution doing? It is saying that the inalienable right to life of every human being at any stage of development must be recognized and protected. We make the laws. Unfortunately, God does not make the laws. He made the scripture, but we make the laws. So what this bill is going to say is, let the people of North Dakota vote on what they want our Constitution to say to protect life and at what stage. And I hope you'll vote green, Mr. Speaker.
Is there any further discussion? Seeing none, the House has before it for final consideration Senate Concurrent Resolution 4009. The clerk will open the key and you may record your vote. Has every member voted? Does any member wish to change their vote? The key will be closed. The clerk will take the record. Final vote shows 57 yea, 35 nay, 2 absent, not voting. Senate Concurrent Resolution 4009 is declared passed. Continue.